Hello, everyone. I hope you can hear me okay, that my voice is not coming out too loud in the speakers. Do let me know if that is the case. I'm very happy to welcome you all here today and also those watching the live stream to this event, Fighting Climate Change Through Human Rights Law, organized by the Norwegian National Human Rights Institution. So my name is Lina Nagel and I come from Bellona, Europa, and I will be moderating this event today. And I'm very excited for our expert panel, and I think it will be a very interesting conversation. So just to briefly introduce the context of this panel, in recent years, the nexus between climate change and human rights has gained more and more momentum. And this is evident by the number of strategic climate change litigation cases, a number that is on the rise. And climate change litigation continues to grow in importance as a way to either advance or delay effective action on climate change. And according to the London School of Economics, the cumulative number of global climate change related cases has more than doubled since 2015. And between 1986, just to illustrate this, between 1986 and 2014, just over 800 cases were filed, while in the last 6 years only, over 1,000 cases has been brought. And according also to the London School of Economics, human rights arguments were identified in 48 cases. Some of the most high-level cases that we might hopefully hear about from our expert panel, who I know have been involved in several of them, are the Agenda case from the Dutch Supreme Court, the Neubauer from the Federal Court of Germany, L'Affaire de Siècle and Grand-Sund from French courts, and People versus Arctic Oil from the Norwegian Supreme Court. We also have, and here I must admit that it is not my national language I will be speaking in, so do bear with me, Verein Klimasenorinen, and I think probably I'll hear someone else pronouncing this a bit better later on, from the Swiss Supreme Court. And lastly, Sacchi et al. Ver Argentina, which was from the UNCRC committee. Our panel today will discuss which issues this human rights cases has so far been able to solve. And this will, I'll go through the program in a short while I introduce the speakers also to give you some predictability of what is coming your way. But following this, the panelists will then explore the next frontier of climate litigation and some of the issues that national and international courts will address in the coming decade as litigation to limit global warming to 1.5 Celsius continues. So with that, I would like to introduce the speakers, and I think I will have to read up because there are so many qualifications that I couldn't possibly memorize this by heart. So first, also to give you an overview of the program, we will have opening remarks from Dr. Christina Voigt on the role of climate litigation closing the ambition gap between what is needed and what is being done. And Christina is a professor of law at the University of Oslo in Norway. She is a renowned expert in international environmental law. Christina is also the IUCN World Commission on Environmental Law. And she is on that, she is not that, I apologize. And the first co-chair of the Paris Agreement's Compliance and Implementation Committee. And for over 10 years, she worked as a legal advisor and negotiator for the government of Norway in the UN climate negotiations. We will then hear from Lucy Maxwell, who will give us an overview or a stock take of legal questions that have so far been solved or clarified. And Lucy is a human rights lawyer and senior legal associate at the Climate Litigation Network, which is a project of the Urgenda Foundation. And in 2013, Urgenda filed a groundbreaking case against the Dutch government to significantly reduce its national greenhouse gas emissions. And since then, Lucy and the team at Urgenda have supported citizens around the world to take their governments to court over insufficient climate policies. And Lucy also supported the legal team for claimants in the People v. Arctic Oil case. And then last but not least, we will then hear from Jenny Sandvik for a forward-looking overview of the next frontier for climate litigation. And Janni Sandvik is the Chief Policy Director at the Norwegian National Human Rights Institution, where she is responsible for their work on climate and human rights. Jenny holds an LLM degree from Harvard Law School, specializing in climate change and human rights, and a master's degree in law from the University of Oslo. And Jenny led the work on a third-party intervention submitted on behalf of the INN-HRI in the Swiss climate case Klimasenioren, which I think you will hear better pronounced when Jenny says it herself, before the European Court of Human Rights. And she was also the lead author of the Norwegian NHRI's report on climate and human rights, and a third-party intervention submitted to the Norwegian Supreme Court in the Arctic oil case. So I think with this, I will give the word to Dr. Christina Voigt. And yes, we are very excited to hear your remarks.
Thank you. Does it work? Can you hear me? Yeah. Thank you very much for your kind, welcoming remarks, and congratulations to the organizers for putting together this event. I think it is extremely topical, extremely interesting, and something that many wonder about. What is the role of climate litigation in fighting climate change or closing the ambition gap, as you put it? I'm happy to say a couple of opening remarks before we then go into the more detailed analysis of cases and legal issues. Now, one of the main topics of this particular COP is keeping 1.5 alive, and maybe some of you went to the consultations this morning on the cover decisions, which is the main outcome decisions where all the political discussions will be captured. And keeping 1.5 alive was the red thread to the discussions this morning. Now, if we think about what keeping 1.5 alive actually means in terms of real actions on the ground, we know that we're looking at an unprecedented challenge. We know it needs immediate, deep, sustained emission reductions right away by 45% around 2030, crossing down to net zero around 2050 and staying negative thereafter. These requires significant transformative changes across all sectors. And these transformative changes have to be fast, but they also have to be fair, and they have to be effective. And all that together, I think, can only be done through real good legislation. And that's my first point. I want to point, before we go to litigation, I just want to say one word about legislation, which is really what we need before we engage the courts, is that we need laws, we need regulation that is commensurate to this transformation, this transformative change that is necessary. We need law as a governance tool to translate that science that we have and the guardrails in the Paris Agreement into real action, that laws that regulate, incentivize, or disincentivize, and some laws even criminalize certain behavior. So that is, in my view, most important, that parties have in place good, solid regulation, effective laws, and then also their compliance and their implementation and their enforcement. But where does litigation come in? We do see many parties adopting acts, climate litigation, climate regulation. But in some cases, it's not yet enough. In some cases, we don't have those laws in place yet. We have action that is not sufficient or insufficient or missing. And this situation can amount to a violation of a right. And when it amounts to a violation of a right, then it becomes an issue for courts, or a violation of an obligation, because you also have to have a corresponding obligation in order to have meaningful judicial action. So the moment insufficient action or inaction on climate change amounts to a right violation, obligation, a violation, or simply to an unlawful behavior, then it is not an issue of politics anymore, then it is indeed an issue of the law. And the third pillar of power, the judiciary, has a very legitimate role to play in this context, because it is called upon acting where governments or individuals or companies are not living up to their obligations, and then courts are required and requested to hold them accountable. And now we've seen this. We've seen many cases coming forward, as you mentioned already, and which we will discuss in the course of this short event, where we see that courts are stepping up to this role, to that legitimate role, which is such a cornerstone in every country that applies the rule of law in its system. But what do courts do? Courts apply the law to the facts. That is basically what courts do. And in context of climate change, we see, competition here. We see that the facts are changing. The facts are, thank you. The facts are complex. Science is complex. Science has a temporal dimension. It has a global, it has a spatial dimension. These are new issues, new facts that come into how courts apply the law. But courts usually don't pull out new things out of nowhere. They apply the existing rules, the existing principles in that new context of climate change. And that's what we're seeing. We see courts, for example, applying constitutional provisions, applying human rights provisions, or the existing climate acts or spatial acts that they may have in ways that is commensurate to the climate challenge. For example, in the German, the case decided by the German Federal Court, the freedoms that are included in the German constitution were applied in an intertemporal manner. Very interesting, something that the Constitutional Court hadn't done before, but it is commensurate to the long-term aspect, the temporal dimension of climate change. Or, for example, the principle of due care in the cases decided in the Netherlands, agenda, but also the Shell case, where that unwritten principle in the tort law, principle of due care, was interpreted in new and fairly innovative ways, taking into account climate science, taking into account the Paris Agreement, human rights law, and unwritten guidance for businesses. We also see other courts, for example, that use new principles in dubio pro natura, for example, that Pakistani courts and the Argentinian court has been applying in the context of climate challenges. And we see, of course, human rights law, as I already mentioned. And what is, of course, the big question is how the newly adopted Human Rights Council resolution on the recognition of a human right to clean, healthy, and sustainable development may play into the interpretation of existing human rights law. But we barely see, if at all, see courts that walk away from their known parameters of judicial behavior and venture into something new. Now, that's not what they do. They apply the law that is at their hand, but in the context, in the challenging context of climate change. And I'm very much looking forward to hearing more about how exactly courts do that. Thank you very much.
Thanks. Okay, I'll try. Can you hear me okay? Yeah, I think it's now coming through. Yeah. Okay, great. Many thanks for the opening remarks, Christina, and I'm looking forward to the discussion. What I've been asked to do today is to look backwards at where we've come in the decade or so that people, communities around the world have gone to the courts and sought climate action through that mechanism. And I think, as Christina said, it's very important to contextualize today's discussion because we are at COP and understanding where climate litigation is fitting into the landscape of trying to ramp up states and private actors' climate ambition. And really, litigation is a last resort when international conferences for decades states haven't followed through in adopting the kind of action that they acknowledge is necessary. So that's the context in which we're here at COP talking about climate litigation, because communities have found that through these kind of negotiations, states may be committing in words, but not taking the requisite action domestically. So what I'll do is set the scene and highlight some challenges that originally people thought were complete barriers to using the courts as a means of increasing climate action, and how gradually over the last 10 years, but particularly in the last 5 years, and really even in the last 12 months, we've seen national courts and a number of international bodies, but primarily national courts, address and clarify issues that people thought could never be resolved, and really making huge progress in identifying the courts as an appropriate forum in which to adjudicate climate ambition. And I'm going to be drawing largely on national cases, largely against states. But climate litigation is a very, very diverse field. And really here what we're looking at is just one subsection, which is climate litigation based on human rights obligations. But there's a whole lot of activity that's taking place against companies, which largely doesn't rely on human rights law, but relies on shareholder obligations and all kinds of commercial law duties. But largely when we're talking about human rights law-based climate litigation, most of the entities being sued are governments. Sometimes it's companies, but more often it's governments. And I'll largely draw on the cases against national governments that seek to increase their overall mitigation ambition. There are other climate cases that seek to challenge one-off individual infrastructure projects, new coal mines or airport extensions, and we can talk about them. But what I'll look at is the issues that courts have to confront when a community brings a case to a court and alleges that a particular national government's mitigation ambition is not in line with the action required to protect the people that it has power over, whether that's under human rights law, which is the focus of today, or other general duties of protection. So that's to set the scene of the kind of cases we're talking about. And you heard some of the countries in which they've taken place. And my colleagues in the Netherlands brought the case against the Dutch government and successfully won that case. And it's on that basis that many other communities around the world have brought similar cases. So if we look at where we are now, what has seemed possible was outside the imagination of most lawyers and most courts even a decade ago. And the nature of climate change posed problems that the law was quite unfamiliar with. And I'll briefly run through them, and then I'll indicate how courts have since addressed those problems. One of the first things that communities used to face a decade ago when bringing these cases to court was the notion that a state's climate ambition is a purely political matter. It's a question of policy choice, and there's no legal content to adjudicate. It's wholly inappropriate for a court. The second problem that communities faced is the notion that we're all deeply familiar with, that climate change is a global commons problem. So how could you ever identify what one state is responsible for, or what harm it has caused through its inaction, or what action it should take as part of the global cooperative effort? Another challenge that communities faced was the fact that much climate harm, though by no means not all, will occur in the future and has not yet crystallized. So in many cases, individuals couldn't say, I've already lost my house, or I'm already suffering health impacts, or my property has been, or my agricultural business has been impacted. And people used to think that that was a complete barrier to bringing a case, because in most instances you go to court when you've already suffered loss. And it's much harder when you're trying to indicate that you will suffer loss because of the inaction now and because of ongoing likely inaction. And so those kinds of features of climate change made some courts in the early 2000s, when people started to bring human rights challenges, very unwilling to become involved. But a number of things happened, and I'm speaking very generally here, it's quite a complex development, but in essence, a number of things happened that made these cases a much more feasible. And that was, as we're aware, a real consolidation of the scientific consensus around how likely future harm is, how clear we are on the nature of that harm, and then, as we've heard, how clear we are on the level of emissions reduction that are required. So there was reference to the halving of emissions by 2030 in the IPCC special report on 1.5 degrees. That made a huge difference to courts' willingness to engage with standards around emissions reduction. And another thing, clearly huge contribution, was states' commitments under the Paris Agreement, which informed domestic litigation. And as part of the Paris Agreement, the temperature goal that was incorporated there was hugely helpful to communities when they were bringing cases and trying to articulate the nature of the duty that their government owed to them. Even if they weren't directly relying upon the Paris Agreement, they were able to use that as a clear statement of intent and knowledge by the state against which they were bringing the action. So I'll turn now to identify some of the legal questions that have been clarified or resolved through the litigation that's taken place. And I'm talking about decisions that have happened really since 2015. And to briefly give you a sense of which countries those decisions have happened in the Netherlands, the first case in the world, citizens successfully sued their government for inadequate climate mitigation action. And that was a 2020 case. You're not doing enough by 2020 in line with what the IPCC said was necessary as a developed country. We had a case in Pakistan in the same year, again affirming that the state had a human rights obligation to take measures to implement its adaptation policy. In terms of mitigation cases, in the last 5 years, we've had decisions out of the highest court in Germany. This year, the first instance court in Belgium. We've had non-human rights cases in France, 2 of them this year, all affirming that existing legal obligations can be applied to the problem of climate change. Even though, as I pointed out, the harm is largely in the future, climate change is a global commons problem, and rejecting the notion that climate change action is a wholly political problem. So I'll drill into some of those finer points, which we can then talk about as we're looking at the next frontier. One of the first things that courts, when they've been faced with these challenges, have really across the board, except for some cases in the US, courts have affirmed that the nature of climate change, the fact that it's a scientific problem and it's a complex political problem, does not mean it cannot also be a legal problem. So they've accepted that, yes, at the very first stage, we're happy to adjudicate these kinds of questions. It's not off limits. And that was a very important threshold in a number of cases. The second thing that courts have identified is that individuals can bring a case to court, even if they can't demonstrate a large amount of existing harm. They can rely on a combination of both some existing harm. So, for example, the Swiss women who unfortunately weren't successful at first within the national level, but what they were relying on were, as elderly women, they were experiencing already the impact of heat waves on their health and their ability to live an independent life. Or in the Netherlands, people were identifying some impact already in terms of flooding and those kinds of things. But courts were willing to accept that you had a right to bring a case based on some current harm, but a huge degree of projected harm based on the IPCC reports. And the Dutch Supreme Court, in its decision in late 2019, specifically addressed this question. And it said, the fact that the climate change harm that's at stake in this question is largely in the future, and we cannot identify precisely who will be affected or how, does not preclude the state having obligations. And so that was hugely significant. And we call that standing for those of you who are familiar with the legal process. Another consideration, which is sort of one of the biggest breakthroughs, was the identification by courts that existing legal obligations, like your duty under human rights law to take positive measures to protect the right to life, the right to property, the right to health, they apply to the problem of climate change. And the Dutch courts, as well as the Pakistan court in 2015, was the first recognition of that there was nothing wholly unique about climate change that meant we couldn't apply existing legal obligations. And what's interesting is that courts have formulated the nature of that general duty to take measures to prevent the worst impacts of climate change in a variety of ways. So the Dutch Supreme Court referred to a duty to take measures that are, quote, reasonable and suitable and consistent with due diligence to counter the genuine threat of dangerous climate change. And the German Constitutional Court, the highest court there, articulated it as a duty to protect life and health against the risks posed by climate change. And the Belgian court earlier this year reached a very similar decision. And the Dutch court in the Shell case this year, again, reiterating this similar language. It's phrased in a very general, in general terms. And then what courts are doing are using a range of sources to determine what the standards are that inform that general duty. But we've seen again and again an affirmation that a general duty does indeed apply to the problem of climate change. And importantly, courts have unanimously rejected states' reliance on what's called the drop in the ocean or the drop in the bucket argument, that their contribution to global emissions is negligible when considered on its own. And a really interesting statement from the German Constitutional Court this year, and I quote here, the fact that the German state is incapable of halting climate change on its own and is reliant upon international involvement because of climate change global impact does not in principle rule out the possibility of a duty of protection arising from fundamental rights. And that's hugely significant. So in the last 2 years, we've seen courts following on from the really groundbreaking decision of the Dutch courts, affirming that you still need to do your part as an individual country, notwithstanding the global nature of climate change. The last sort of territory that courts have engaged with, which is particularly important and really feeds into what Jenny will talk about the next frontier, is having established your right to bring a case to court, the general duty, and the fact that you have an individual responsibility. Courts are now grappling with what are the standards we use to inform that duty. How do we know when a state is doing enough and when is it falling short? And what courts have begun to engage with are a range of standards. They're drawing on principles from the UNFCCC, principles from the Paris Agreement. So equity and common but differentiated responsibilities, the notion that a developed country has committed in the Paris Agreement to take the lead. That's relevant when assessing a state's mitigation ambition. They're looking at IPCC science on effort sharing and how to split the global carbon budget. They're looking at states' own scientific independent institutions and their advice on what a state's fair share is. So in the German case, it was very significant that the German independent scientific body had indicated that that a fair German carbon budget, which was a per capita budget, would, if they continued on their current emissions trajectory, be exhausted by 2031 in essence. So courts are looking to scientific standards and legal standards and independent bodies as sources to substantiate or fill out that general duty and continue the process of adjudicating whether a state is doing enough. And I think that's really where the work of climate litigation is headed. How do we put before the courts evidence about the sufficiency of a net zero target, about the use of offsets, about what countries are doing with their fossil fuels, and further developing and articulating the nature of that duty now that we've established so many of the basics, and through a lot of hard work by many communities and their legal teams, through wins and losses over the last decade. But that's where we're at now. So look forward to talking about what's next. Thanks.
Can you hear me? Okay, thank you. Thank you so much. And thank you, Christina and Lucy, for those introductions. And I'm absolutely delighted that you're all here and also in the stream. I represent the Norwegian National Human Rights Institution, and we are increasingly involved in climate and human rights issues. Now, first, some of you might wonder what the human rights issue really is. But that should be no secret. 200 lives lost in Germany, Europe during floods this summer. A number of 600 persons prematurely dead in Canada, British Columbia during heat waves this summer. And that's only at 1.2 degrees. And this COP is about keeping 1.5 alive. So this is very much a human rights question. And we're not on the fringes. We're at the very essence of human rights. The right to life, the right to physical integrity. So I'll do something which feels a little bit daunting, and that's to look into the future. Going forward, what might be the next unsolvable puzzles that climate litigation might actually help to solve? And I'll pick up from Lucy's stock take of what courts have established so far and give you a glimpse of what courts might be able to solve going forward. Now, all of this will, of course, depend on court cases being brought, but there are a number of 1,500 court cases ongoing at the moment about climate in various forms. So there are indeed lots of cases, and there are more coming. So there are 4 emerging tendencies that I would bring to your attention. First, while we know that climate change is of global nature, it is increasingly recognized by courts that states may have a responsibility also for climate harm outside of their borders. The German Constitutional Court, which is an important court in Europe, established that Germany may have responsibility for climate harm affecting individuals outside of its borders because it in part originates from emissions in Germany. A few weeks ago, the UN Committee on the Rights of the Child established that states may have a responsibility under the UN Convention on the Rights of the Child towards children outside their borders suffering climate harm that is partly caused by emissions under the first state's effective control. And effective control includes emissions exported. Now, even courts that have adopted a more reserved position, such as the Norwegian Supreme Court or indeed the Federal Court of Australia, have recognized the simple fact that emissions under the effective control of a state, for instance, exported fossil fuel emissions through combustion, equally harm citizens within the border of the exporting state, thereby triggering the responsibility of the exporting state without even engaging extraterritorial responsibility. So that's already sort of encompassed, even though the Paris Agreement only counts territorial emissions. Under human rights law, a state may well be responsible also for the climate harm caused by its exported emissions. And here we know that attribution studies and also studies on climate sensitivity will continue to inform court cases. As we saw in the Federal Court of Australia, they had identified 100 million ton of CO2 in exported coal emissions as sufficient to constitute a reasonably foreseeable risk of triggering tipping points that could unleash a 4-degree hotter world. So that's the figure that we're down to, and the science is increasingly getting more granular on this point. Second, it's on scrutiny of targets. So the German Constitutional Court said that a target set in time, 2030 or net zero in 2050, in itself is meaningless because it doesn't say how much emissions you spew out in the meantime. So what's required is not only to have a target, but to have a reduction rate that is sufficiently specified to avoid overshooting emissions that would cumulatively only invoke for the harm. So what we expect is an increased scrutiny of net zero targets. We expect increased scrutiny of the reduction rate itself. And we also expect increased scrutiny of overshoot of past emission targets. We see, for instance, the French Administrative Court requiring the state to correct previous overshoots by reducing even further the emissions going forward so that you don't end up with an overshoot of emissions even though you reach future targets. And we also expect scrutiny of offsets. And this should be kept in mind for the ongoing negotiations on Article 8, that offset systems need to be transparent and concrete in a way that allows for judicial oversight, because otherwise a state might find itself in a difficult position a few years down the line to give evidence that the offset did in fact reduce emissions. And the human rights rationale behind all of this is quite simple. Any policy that does not effectively cut emissions, but contributes to push the burden further down the hill, inevitably puts that burden to future or younger generations, thereby affecting their human rights. So this is not something that we could just scuff under the rug. It's the human rights consequences of inaction will be felt, and that harm is increasingly adjudicated. Thirdly, we expect limits to fossil fuel exploitation. We expect stricter judicial control, scrutiny of continued fossil fuel exploration and exploitation, and step with the growing consensus that new investments in oil, gas, and coal are incompatible with the 1.5 trajectory. And we have seen the start of this development by the Dutch court against Royal Dutch Shell, which of course is subject to appeal, but where the court ordered Shell to reduce its emissions by 44% by 2030 across scope 1, 2, and 3. And similar cases are launched against Total, with others forthcoming. And in the Shell case, the reduction obligation concerning scope 3, the combustion of salt, oil, and gas, was not a duty of result, but rather a duty of care. But it is possible to anticipate that that duty of care could be further more strict upon appeal. And it's tempting to sort of speculate what the duty of results could be for scope 3 emissions. Is it possible perhaps to envisage a duty of guardianship towards those hydrocarbon reservoirs instead of selling them off? Could we perhaps in the future expect courts to say, if you are in exclusive control of a reservoir, you are to guard that reservoir? The Dutch court case was based on due diligence, but informed by human rights. And that speaks a simple truth, that the dynamic interpretation of human rights that we see, that's sort of tied in the judicial understanding, will spill over to other areas of law. And the duty of care, which in many jurisdictions is an unwritten duty of care that can engage compensation responsibility, is in essence a duty to conduct yourself in a manner that is socially acceptable. So the human rights developments that we see, they inform what is socially acceptable. This brings me to the fourth, sort of looking down the line, what is coming. The fourth and final point, and that is that the duty of care that the Dutch Supreme Court, the Dutch court in The Hague relied on, and which also was the legal basis for the Federal Court of Australia in another case concerning coal. That's not only a legal basis for prospective actions going forward, it is also a legal basis for retrospective claims of compensation going backwards. And that's a development that is expected to be more and more predominant. Compensation claims against both states and companies. So what we have witnessed so far is a rapid legal development. And it seems to be like a race to the top. Because the legal standards in this domain and in this cross-fertilization between courts is set by the most progressive courts. And we expect that this will continue as the dangerous effects of climate change are increasingly felt by humans and continue to inform our perceptions of lawfulness. Thank you.
Thank you very much. That was enlightening. And I'm very excited to now continue the discussion in a panel. And before, I have some questions prepared, but I wanted to ask first if there's anyone from the audience who maybe have some clarifying questions that might be important to discuss before moving forward. No? Oh, yes, apologies. Maybe. We'll try to get you a microphone here so that you can speak into that.
Thanks. Okay, cool. That's very loud. Okay. No, so I was asking, you're all very much involved in the negotiation of human rights language at the moment. Are you informing and drafting language? You definitely need to be doing that. Really, like what you've said is like absolutely critical for the language that is developed. And I mean, there are caucus groups who are developing language, and yeah, I'm just wondering if you're involved in those spaces to support the development and drafting of language. It's absolutely.
Yeah, there's certainly huge civil society input into that. And I think probably just our organization is not doing that directly, but yes, absolutely. The points that are being made are being driven by others in civil society. Absolutely. So yeah, wholeheartedly support it. I think our efforts are just in a different arena, but yeah, it's completely complementary. Yeah.
Okay, cool. And then I just had one more question. You spoke about these precedents are being set by some of the most progressive courts, but then you also have investor-state dispute settlement courts. So how are you challenging the most regressive courts?
I'm not sure which one of you would like to kick off that one.
Well, in some of there is some litigation happening in the investor state, arbitration system in relation to positive mitigation action that states have been taking. And certainly the Energy Charter Treaty and its effect and its quite regressive effect on positive climate action is a target of, again, other civil society groups really mobilizing to try and inform its future, because we see the Netherlands has been sued, for example, as a result of its phase out of coal power. And so certainly that's a real on the agenda of a lot of people working on climate action, is to work out how to deal with those ISDS disputes.
Great. Yes.
Jump in. To the extent that any of these cases are solved on a constitutional basis, that takes precedent over other legal norms. So that would be sort of interesting to see. But a good question. Thank you.
Christina, would you like to add anything there?
Yeah, I think what we haven't talked about yet are supranational courts. Every example we mentioned was basically in national courts. Supranational courts have just recently been involved, especially the European Court on Human Rights, and maybe potentially, who knows, the International Court of Justice. And that also may tilt the scale quite significantly once we have a supranational court rendering judgments on human rights obligations in this context.
I saw that there were some hands, so I will continue if that's okay. Or maybe I should ask some of the questions we preferred before first. So I will let you come in a bit later in the event to probably finalize. So first I had a question to Christina. So under the positive obligation to protect human rights, states have to implement appropriate measures to protect the public. How can states decide what protection is appropriate in the wake of climate change? And also, can the term highest possible ambition from the Paris Agreement contribute here?
Very good questions. Well, first of all, states do decide this all the time by submitting their NDCs, they're setting their own targets, and then they have to follow up with effective national measures, as it's written in Article 4, paragraph 2 of the Paris Agreement. And every party is taking these measures, and in implementing or designing them, they're taking a position on what are effective and appropriate measures in their own view. Of course, they may be appropriate, or they may not be appropriate. And this is exactly what courts are currently being asked to adjudicate upon, whether these measures amount to appropriate measures or not. So we will see more of this. When it comes to highest possible ambition, Article 4, paragraph 3 in the Paris Agreement is an expectation that could inform a due diligence obligation, that could inform an obligation of conduct. It's not an obligation of result, but it's also something where we've seen courts start engaging with. Under the Paris Agreement, we have no mechanism to pick up on that, and that was not desired when the architecture was set up. But domestic courts have started engaging in thinking about is an NDC, is a climate act amounting to that highest possible ambition, or is there any higher ambition possible? And that's, I think, quite an interesting development.
Yes. Lucy and Jenny, would you like to add anything on this? If not, I'll move on to the next question.
Yeah, go on to the next. Yeah, fine.
So the next question, which is, I think, to all of you. So whoever would like to contribute. So to determine the threshold for dangerous climate change and the minimum rate of emission cuts necessary to mitigate threats to protected rights, courts have relied on best available science from the IPCC and the temperature goals of the Paris Agreement. And so far, courts have not been explicit on whether it is the 1.5 or 2 degree target that is necessary. Do you think that that might change in light of new knowledge, most recently by the IPCC report from the summer?
Sure. Yeah. Do you want to go, Jenny? Go ahead. Oh, maybe what's. Were you writing an answer?
Pending for the European Court of Human Rights, and it's prioritized by the court. We argue that the 1.5 degree target must be the relevant target on the human rights law, because we know the devastating impacts for human rights and physical integrity if we allow temperature rise to go above 1.5 degrees. So I do believe that that's where we're headed and where the legal emerging tendencies are converging against it.
Christina, but I completely concur, but we see also the general discourse on climate change is heading in the same direction. 1.5 is just in the last 2 years been the target, and barely any talk about well below 2 degree. 1.5 is also well below 2 degree, by the way, but it's a general tendency we see that 1.5 has gained a lot of weight in discourses, and that is then reflected, of course, in how courts look at this issue. And I don't know, I dare say that if from this COP we get a decision that is very explicit on 1.5, it probably would enhance and encourage and inform courts also looking more, focusing on 1.5 rather than anything above it.
Great. I know we agreed on some higher order of the topics, but we don't have that much time left. And there was one question I really wanted to ask you on one thing that Bellona works quite extensively on. And in particular, that is the Precautionary Principle, which is a core principle of international environmental law, which recognizes that delaying action until there is compelling evidence of harm will often mean that it is then too costly or impossible to avert the threat. So how has this principle been interpreted in climate cases with regard to negative emissions technology, which is, of course, what Bellona works quite extensively on?
So, yeah, just to start, negative emission technologies has been theme of some court cases so far. For instance, in the Netherlands, the court case in Ireland, and also in Germany. And what the approach that those Supreme Courts have taken has been quite prudent. And they've said basically that according to the precautionary principle, that one should be cautious to base rejection trajectories on technologies that are presently unscalable or not discovered yet. So that the reduction trajectories must take as a point of departure the technologies that are known, that we do have, that we know today can safely take us to net zero. So the approach has been rather, rather cautious, I'd say.
Christina and Lucy, would you like to add something there?
Well, I mean, precautionary principle has a substantive element, as Jenny went into how to act in the face of scientific uncertainty, but where the risks are high. But it may also have a procedural element, and that relates to the reversal of burden of proof, which I think is maybe even the more important one in a judicial context, because traditionally it is the claimant that has to prove that a certain action by the respondent is harmful and leads to a particular harmful outcome. But if you use the precautionary principle as a means to reverse this, it would really pave the way for much more litigation in this area. And it has been done, not in a climate context as far as I know, but it has been done in some national courts, but only very sparely. But I think if we see more of that procedural aspect coming forward, it could really help litigation.
Lucy, anything to add?
No, I guess I would just say that the IPCC's own description of the risks that are entailed in the use of negative emissions technology, and the fact that it's very hard to scale and that it entails, great deal of uncertainty, was cited by the Dutch Supreme Court when it was assessing the government's plans and the government's proposed reliance on not much reduction in the short term, but we'll do a lot in the future and we'll suck it all out of the atmosphere using negative emissions technology. And the Dutch Supreme Court made an explicit finding that excessive reliance on such as yet untested technology would constitute an irresponsible risk. And so there we have a court looking at what the IPCC has said, looking at what a state plans to do and saying, we're not content that that's a reasonable and appropriate measure. And that's the standard we're using to assess your action.
Great. And we're going to open up for questions after this last question to Lucy. So another alternative to determining the scope of states' positive obligation is to calculate their fair share of global emissions. But this is a difficult question for a court to determine, particularly as the negotiators at COP have not been able to resolve this issue. So, Lucy, how could the concept of fair share be operationalized in climate litigation?
Sure, I think it's a good question, and it's one that communities bringing climate cases are grappling with and have grappled with for the last 5-10 years. And there are a few different approaches to articulating and defining a state's fair share that have been developed by different communities and their legal teams. And I can briefly touch on a couple of them, but basically the Dutch decision was premised on an articulation of a state's fair share. And that case, which was a 2020 case, used effort sharing literature about how to split the global carbon budget, which had been included in an IPCC report in AR4. And so the plaintiff was able to use that IPCC literature saying, this is what scientific experts say a developed country's fair share is, based on the different equity measures in the literature. Other communities have taken different approaches in trying to specify fair share. They've, in the German case, for example, referred to what their own scientific independent institution came up with as a carbon budget. And that was closer to a per capita distribution of the global carbon budget. Sometimes communities refer to the global average of what the 45% reduction by 2030. And so they say, look, that's the bare minimum. We can see that from the IPCC report. Let's hold the state to at least that, if not much more. And then at the very other end of the spectrum, there's a lot more innovative and ambitious research, particularly coming out of New Climate Institute, Climate Analytics, Professor Rajamani from Oxford, indicating doing new analysis of the effort sharing literature and ensuring that it would be consistent with the Paris Agreement temperature goals. And happy to talk about that, but there are ways in which courts have adjudicated fair share and plaintiffs are continuing to put new arguments forward about fair share.
Thank you very much. Then if it's all right with you all, I'll move on to some questions from the audience. I think you, sir, you've had your hands up a few times. So please keep the question rather brief.
Can you hear me? Thank you. Tobias Smith from the Geneva Water Hub. I'd just like to raise a question because we've seen your presentations were excellent and thank you very much for all your interventions. I would like to talk about something which is perhaps a little bit outside litigation, which is a development which took place, I think, in 2019, that the Netherlands questions were posed in the context of the Universal Periodic Review in Geneva regarding the Netherlands' relationship to the extraction of natural gas in Groningen province, which caused earthquakes and damage to homes. And for the first time, environmental and human rights law was used in Geneva to recommend action for the Netherlands on fossil fuels over the period of the next 4 years. Now we've gone ahead with this principle and had national consultations in Tanzania and in Paraguay and in Bolivia and in Belgium to submit stakeholder reports to the UPR, encouraging questions to be posed to the country in question when they appear before the UPR. Now, this is an entirely different thing to climate litigation, but based on human rights law. And it's a relatively new practice. And I just love to hear your comments on that emerging principle. Thank you.
Anyone would like to kick us off? If you have any comments on that topic?
No, but I think that's an interesting comment. I just hosted a conference in Oslo last week on treaty bodies and other means outside the courtroom that could actually enhance or at least shed light on what's happening and give recommendations to what states can do. And we addressed also the UPR as well as what treaty bodies are currently doing. And I think you have to have a look at the whole spectrum of judicial and quasi-judicial and extrajudicial elements to see what can incentivize or nudge the states to do the right thing. It doesn't always have to be a court. There are many other avenues out there as well.
Thank you. Yanni and Lucy, any additional points there before we move on?
No, I think I'll allow for more questions.
Yeah.
All right, fantastic presentations, really thought-provoking. My name is Aoife Nolan, and I am a professor of international human rights law at the University of Nottingham, but I'm also vice president of the European Committee of Social Rights, which is a Council of Europe body that monitors the European Social Charter. And I'm very interested, there was a big focus obviously on the domestic today, but Jenny, in your comments, you made reference to the work, I think, of the Committee of the Rights of the Child. And I'd just like to hear maybe some thoughts that you might have about the balance between whether people trying to use climate litigation as a way of advancing, tackling the emissions gap. What should the balance, how should we strike the balance between efforts aimed at the domestic bodies and those aimed at supranational bodies? And that's a very broad question, but it's really to get your thoughts about the interplay between the domestic and the international.
Yanni?
Yeah, I think it's a very good question. I think that those two work in tandem. So, and I think that what the UN Committee on the Rights of the Child just recently did seems quite well placed really in these developments, because if an international body or treaty body moves ahead too fast, that sort of jeopardizes its legitimacy really. So it needs to be at pace with national developments. At the same time, there might be many reasons why a national court is perhaps too closely related to the problem and the vested interest at heart to be able to pronounce the kind of courageous judgments that this hour needs. So I think an interplay between the two, and that's something that we really saw, I think, that we can see as a result of that decision by the UN Committee on the Rights of the Child, even though it was heavily criticized by those children, and I'd understand them personally. I do think that it's sort of a gift in disguise, because what it does is, even though it dismisses it because the complaint hadn't been through any national remedies, so it's dismissed on a procedural ground, the committee does say that states do have responsibility for extraterritorial harm, as just a part of establishing jurisdiction, as a treaty body must do. And that provides an avenue for national courts to interpret the UN Convention on the Rights of the Child in ways that it would perhaps not have done
had it not have this authoritative decision by the committee itself. So for instance, in Norwegian courts, which I know, the decision by a UN treaty body is accorded significant weight in interpreting a convention. And we just saw that with the Convention on the Rights of Civil and Political Rights, that was accorded significant weight towards the rights of the Sami people. So in Norway and in other places, this decision, as well as other decisions, may give rise to dynamic interpretations going forward nationally.
Christina, would you like to add anything?
No, I think Jenny captured that very eloquently. It was actually a very interesting decision by the CRC because it did say on procedural grounds that the claimants were not successful, but it then came with findings that really did push the envelope quite far, and that may inform the national cases that I'm sure will come forward once these claimants or others bring that to national court. So it's actually really interesting dynamics there. And we have the Torres Strait Islanders case at the Human Rights Committee that's not decided yet. Well, we still have to see what comes out of that one, and if they find it along the same lines and how they speak to the other committee in the human rights system. But there's a lot of excitement about this.
Lucy, any final remarks?
We'll have another question. I'm happy to talk about it.
We're running a little bit over, so as long as it's fine with you, it's fine with me. So yeah, we can take one more. Excuse me. I think you've had your hand up. I think you're gonna have to come over here. It's the wire is not long enough.
Hi, my name is Maria Lundberg. I'm a colleague of Christina, and I know Jenny also from a lot of good talks that we have within this field. My first question, it's a comment actually on your saying on the CRC decision. They elegantly avoided the Committee on the Rights of the Child to really take into account the best interest of the child, because that would be, I think, very interesting in any decision coming out from the Committee on the Rights of the Child for the future. I don't know what your points of it. That I just took it away because it never came to the merit. Next question is a little bit relating to this human rights aspect, and it was asked before, where do they get into the Paris decisions, etc. I have followed the platform for Indigenous, local and Indigenous communities, and they are lobbying hard, and it seems like the presidency is taking into account human rights issues for Indigenous and the local community, at least Indigenous. And there we have a large source of different human rights law. I would like you to comment, because most of these decisions are on the right to life, as I understand the right to privacy. They are in that field. Here we have a large resource. This kind of human rights law is also working in a different way. It's telling us how to make mitigation or adaptation, because in the Norwegian case, as I understand it, we want to have more windmills in Norway. We couldn't do it because we did it in the wrong way according to human rights towards the Sami people. So here, those limitations I would like you to comment a little bit more on. And then I'm very pleased with this other question she was asking. Thanks.
Thank you very much. So who would like to start? Lucy?
Sure. Yeah. So I think part of what you were saying, I know there were a few different questions, but I'll take the last one at least, that in terms of the role of Indigenous rights arguments in human rights climate change cases. One of the very first ones that was unsuccessful in the sort of first generation was in the Inter-American Court, and it involved Indigenous peoples in the north of the US and in Canada. And I think what we see there, and it feeds into the question just before that, which is what has changed since that complaint, which was a human rights-based complaint with Indigenous rights components, and why was it not accepted as justiciable and able to be considered. One of the things that's changed significantly is the work of international UN bodies since 2008, and not necessarily the courts or tribunals, but the UN Human Rights Council and the UN treaty bodies in their other functions, issuing statements and reports identifying the link between climate change and human rights. And I think that cannot be overstated. And I was remiss to not mention that as one of the huge factors that's changed the landscape and meant that national courts are willing to take these cases. And so the only other point, I'll let the others comment about Indigenous rights cases, but one interesting way that we're seeing it in the Australian context is we have two complaints that are happening. One brought by Torres Strait Islanders, who are First Nations people in the north of Australia in islands there. One several years ago was brought to the UN Human Rights Committee, and it does include Indigenous rights as a big component, as well as right to life and health and family life. And then just 2 weeks ago, a national case was brought in tort law, in negligence, including elements regarding native title and the unique island custom connection of the Torres Strait Islanders to their land. And so there we see two different methods of seeking to enforce the rights of First Nations people against Australia, one an explicit human rights model and the other one a negligence one. And so that's, I guess, a sense of the variety of different techniques. And I'll open it up to the others.
I can just answer to the question regarding Article 3 on the UN Covenant on the Rights of the Child, the best interest of the child, and the duty to take the child's best interests into account as a paramount consideration in any decision concerning children. And I'd say that even though this particular case was dismissed by the committee has indeed said in state reports and also in other forums that the rights of Article 3 must be taken into account. And I think that it's fair to say that it's not sort of it's not up for question whether these kind of decisions, mitigation decisions on fossil fuel extraction, I think it's not up for debate whether or not these decisions affect children. So they are within the scope of application of Article 3 already. I don't think we need actually a pronunciation by the committee to establish that before national courts or indeed before national authorities. And that's what we do with regard to the Norwegian government. We argue that it's undoubtedly something that follows from the covenant and Article 3 that one should assess the best interest of children over their lifetime when taking decisions that will affect them concerning, for instance, exploration and exploitation of fossil fuels.
Thank you very much. I think we are actually running quite over time, so I will let you give the final remarks. And then I think running over and still having a lot of questions in the room shows just how much of an interesting topic this is, and just how much you might want to stand outside and discuss after the event and get in touch with all of these our great experts here today. So with that, maybe Christina, you would like to make some final remarks?
Maybe just a comment or food for thought, maybe, because we've seen a lot of litigation focusing, if at all, on when focusing on the Paris Agreement, bringing in the temperature goal, which is Article 2, paragraph 1, literal A. And that's important, and it helps to conceptualize mitigation and what lies ahead of us. But the Paris Agreement also has two further goals on adaptation, and in particular on finance. And it's that last one, which so far has been flying a little bit under the radar in litigation, making finance flows consistent with low carbon and climate resilient development. And what does that mean to regulate the corporate sector, financial sector, and so forth? And I think here is a potential to think a little bit more about what kind of legal obligation may actually be able to be derived from that third goal that is included in the Paris Agreement.
Would you also like to add some final remarks?
Sure. Yeah, I think I'll take up Christina's challenge that we as lawyers and litigators we have just been talking, or I mainly about mitigation obligations, but I think the question from the audience is saying how you mitigate and how you treat people in your mitigation actions matters hugely as well. And I think that there are already cases, as you've mentioned, about doing effective consultation and making sure that the community has support and you're not further infringing rights through your mitigation action. And I think that will be an absolute crucial element of further scrutiny of states as they go forward.
Thank you. And lastly, Yanni?
Yeah, I would just echo that and thank you all for coming and for posing so many interesting questions to us. It's just been such a privilege to talk to you all, and I would definitely love to discuss more if anyone have a burning question that there wasn't time to ask. So thank you so much. And thank you.
And then thank you to our great experts.